want to order arbitration because it helps them with their docket. We'll talk later on about what you have to prove and what you have to show in order to vacate an arbitration award. And I think we've looked at 385 cases, and there was something like 382 of them where the courts refused to vacate arbitration awards. Why? Because if the courts are in the business of vacating arbitration awards, if that base of appeal under the FAA wasn't so narrow, it would just be the court of appeal for every person who didn't like an arbitration, would just simply be able to go to the court and second guess the arbitration panel. And this was all decided in a case. It wasn't really decided because it was best summarized in a case from the Seventh Circuit with our friend Judge Posner. And Posner's a law and economics guy from Chicago, and Judge Posner's done more for curtailing individual rights, maybe the next Judge Easterbrook. But he actually said it. We actually quoted it. We asked you to read the Bavarati case, not because of the substance of the case, but just an oft-quoted statement that Judge Posner actually made. Short of authorizing trial by ordeal, maybe in the old days when you had trial by ordeal, they put someone in water if they sank, they were guilty, or they were innocent if they drowned, or more doubtfully, trial by a panel of 3 monkeys. Parties can stipulate to whatever procedures they want to govern the arbitration of their disputes. And I think that best summarizes the federal court's view of arbitrations. They just don't care. You can have the most outrageous set of facts, and the courts just do not want to open the door to those appeals because it's a slippery slope. If they start vacating arbitration awards, there's going to be a line of dissatisfied parties, and it's generally going to be the respondents who have the deep pockets to finance these appeals, that are going to be beating their way to the court saying, hey, this court, this arbitration panel, failed to consider pertinent evidence, or this arbitration failed to disclose some obscure conflict of interest. And that has basically been the law, and it will continue to be the law. One of the cases that you folks are supposed to read was the First Options of Chicago versus Kaplan case. And that case has also changed a bit since it's first been put in your casebook, even though I noticed your casebook is relatively recent. Who decides the issue of arbitrability? What if a client says, gee, that's not my signature, or there was fraud in the inducement. The broker lied to me when I signed this contract to arbitrate. I thought I was signing my W-9, or I thought I was signing my IRA account, and I didn't know that there was an agreement to arbitrate. There was a fraud or a misstatement that induced me to sign this agreement, and it was not what I thought I was signing. Now, I don't want to arbitrate because, after all, that contract was, procured by fraud. I was fraudulently induced to sign it. So why should I be held to arbitration? Who decides that issue? Well, really, it's the arbitrators who decide whether or not the contract even applies. And it's actually hits home recently in a case back in 2003, the Howson versus Dean Witter case, and the Green Tree Financial case, where most arbitration agreements prohibit class actions in arbitration. In both those instances, the courts said the NASD arbitrators are comparatively more expert about the meaning of their own rules and comparatively better to able to interpret and apply them. That's interesting because you read First Options versus Kaplan, you have to go to the court in order to secure arbitration. You have to go to the court and say, hey, court, you got to go compel arbitration. This is consistent with the Federal Arbitration Act. No, it's the panels that often will decide jurisdiction. We've had many cases where panels have said, we think you're within the 2 years from associated with a member. We think this claim arises in connection with the member's business because it involves failure to supervise or selling away. And a panel will say, hey, we think there's jurisdiction here, and we're going to hear this case. And if you don't participate in these proceedings, you do so at your own peril. Because at the end of the day, if an award's rendered against you, the other side can go and enforce that award. And if you don't pay an award within 30 days, it's also in your casebook, your NASD license, your NASD membership becomes revoked.